So what is a trust? How can you use it? And can it be tax-free in the United States of America? Hello there, my name is Javier Correa. I'm the tax director here at the Rothbard Group, and I'm also a licensed enrolled agent in the United States of America, fully admitted to practice before the Internal Revenue Service. Now, today's topic is trusts, and specifically trusts in the United States of America. Now, the reason why here at the Rothbard Group we go back to trusts as one of our fundamental tools for wealth planning, tax planning, and overall family structuring is because we work with families and individuals who want to establish a true legacy. Individuals who want to make sure that the work they've done is not only going to outlive them, but it's going to last for decades and maybe even centuries to come. Family is at the heart of what we do as well. And in many cases, our clients want to make sure that their kids, their grandkids, and in some occasions, even their great-grandkids are properly provided for, and they are in many cases protected, and that includes protected from themselves, protected from decisions that might not be ideal. Maybe they don't marry the ideal person. Maybe, they've grown up in excessive wealth and they don't have the same idea surrounding money and how to manage it and how to use it properly. And this is where, a lot of our clients will come to us and say, especially when they reach a certain age and they are really concerned about the continuity of their fortunes, of their estates, of the money they've actually been able to accumulate in their productive years. And so from a tax perspective, this is also extremely important. And in many cases, we sit down with clients and discuss what tax neutral avenues we actually have to encourage and to help them with the wealth preservation objectives they want to achieve. Now, when we're in the world of international wealth planning and tax advisory services, the trust often comes up as one of the premier options and tools that wealthy individuals have and wealthy families have to make sure that these legacies we've been talking about truly last for decades, if not centuries. Now, we've done other videos about Panama private interest foundations, which are another great alternative, but those are mostly rooted in the civil law system. Private interest foundations have legal personality. They are kind of like the merger between a kind of a trust and a corporation. They function differently. And if you're curious about those, we recommend you check out that video on our channel. Now, trusts are, I guess, the other alternative, the other kid in the room when it comes to, wealth management, succession planning, and also, potential tax optimization for wealthy families that are looking at a multi-generational outlook. So let's talk about trust for a sec. Let's first establish what a trust is. I'm going to simplify the concept of a trust so we have a general understanding of what that is. And then I want to focus specifically on U.S. trusts and how they could potentially be tax-free for entrepreneurs and investors that are international, meaning foreign entrepreneurs and investors. Let's take a look at a trust for a sec. What is a trust? So, unlike a private interest foundation in Panama, a trust is not a legal person. So that means unlike a corporation or a foundation or a limited liability company, a trust doesn't have legal personality. It's not a person for legal purposes. It doesn't have personhood, okay? A trust is a legal relationship, a legal arrangement between different parties. And those parties are the following. So imagine you have three people. Imagine you have a triangle. Right? And so you are the first piece of that triangle. You are a successful entrepreneur, investor, you've accumulated wealth, and you're deciding to put that wealth into a box. Let's say you're putting some cash, you're putting some stocks, potentially some real estate, whatever it is you want to put into that box. And now that box contains a series of assets. And now you're giving that box over to a trustee. And a trustee is a separate person, which can be an individual, or in the 21st century, it is more common for that person to be a professional trust company that manages the trust as a professional trustee. So now you're giving that box to the trustee, and the trustee will legally own those assets, but here's the catch. The trustee is not the full owner in the traditional sense of the word. The trustee can't really benefit from those assets because those assets are given to the trustee by you for the benefit of a third party that is known as, you guessed it, the beneficiary. So you as the settlor put the assets into the box is then given to the trustee holds legal title to that property, meaning the trustee owns it, but the trustee owns the box and the assets in the box for the benefit of the beneficiaries. And the beneficiaries can be your children, your grandchildren. They can be your alma mater, for example, if you want to support your university. It can be charities. It can be the causes you believe in. It can potentially be your church. I mean, you name it. There is a lot of freedom when it comes to designating who the beneficiary of a trust could potentially be. So that means that basically the trust splits ownership into two different categories. The trustee is the legal owner, but the beneficiary is really the one who can take advantage of the economic benefit that those assets are actually generating. Now, there are multiple types of trusts, and I'm not really going to go through each and every one of them during this video, but what you do have to know is that depending on how you structure the trust, you can get different results. You can have revocable trusts, where you as the settlor basically hold the freedom to say, hey, I'm going to terminate the trust, give me back the assets, give me back the box. There can be irrevocable trusts, where you, once you hand that box of assets over to the trustee, you essentially can't get it back, or at least it depends on how the trust is drafted, but generally speaking, once it's done, it's done. It's something that is, like the word implies, irrevocable, irreversible in the vast majority of cases, although like everything in the law, there are always exceptions. And for tax purposes, as we're going to see in a few minutes, there can be grantor trusts, non-grantor trusts from a U.S. perspective. So, I mean, trusts by definition are very bespoke instruments, which means that really, even though there are general guidelines as to what trusts are as legal relationship between the parties that I just described, you will always see that a trust is, or should be, tailor-made to the specific facts and circumstances of each individual. From a tax perspective, this really has a huge impact. And here at the Rothbard Group, we truly focus on that tax element. So now let's talk about trust taxation in the United States. And in particular, I want to talk about trust taxation when the settlor of the trust, or when the parties in general of the trust, not just the settlor, are non-U.S. persons for U.S. tax purposes. So as you've seen in some of our other videos, the Rothbard Group truly focuses and thrives on assisting foreign, non-U.S. individuals access the United States of America, grow their wealth by investing in the United States, grow their businesses by servicing U.S. clients. This is truly an area where our expertise shines. And so when you talk about trusts, you first have to determine, okay, are we talking about trusts that are linked to non-U.S. persons or U.S. persons? So let's first redefine what a non-U.S. person for U.S. tax purposes is. So a non-resident alien, which is somebody who is not a citizen of the United States, not a green card holder, and somebody who does not live in the United States or does not spend enough time in the United States to meet tax residence requirements under the substantial presence test. Essentially, you are a non-U.S. person for U.S. tax purposes, a foreigner, and you are only taxed in the U.S. on U.S. source income. So far, so good. Now let's look at the trust itself. So as I was mentioning earlier, the trust is not an entity per se, but rather a legal relationship. So the IRS isn't really going to look at where the trust is actually formed, meaning that the fact that a trust is formed under the laws of South Dakota or Wyoming or Delaware or Florida or Texas is not really going to be the deciding factor in determining whether or not the trust is actually subject to U.S. taxation on worldwide income. Rather, the IRS is going to apply two specific tests: the court test and the control test. Now, these tests in of themselves are quite complex, and it would take a whole series of videos just to dive deep into each one of those. But what I'm going to tell you right now, just for simplicity purposes, is that as long as you fail one of those two tests, meaning that you only meet the criteria for one of those, then you are not, or your trust rather, is not going to be considered a U.S. person for tax purposes. In other words, a trust has to meet both the control test and the court test in order to be considered a U.S. person for tax purposes. So, what does this all mean? If you are a foreign person and you settle a trust in the United States, and your beneficiaries are also foreign persons, so again, that means that you, the owner of the assets, putting the assets into the box and handing it over to the trustee, you have to be a non-U.S. person, so not a citizen, not a green card holder, and the beneficiary of the trust you're creating is also a non-U.S. person. As long as that is true, then provided that your trust is structured to intentionally not meet one of the tests, either the court test or the control test, then your trust will only be subject to U.S. tax on U.S. source income, regardless of the fact that it is formed under the laws of a U.S. state. And think about that for a sec. That's very powerful, because that means that if you're working with the right tax practitioner, if you're working with the right U.S. tax advisor that understands the nuances of international global tax, you could potentially get the best of both worlds. You can have a trust that is formed under the laws of a state like South Dakota, Wyoming, Delaware, Nevada, which are jurisdictions that are widely known and respected for their long-standing trust laws, their strong statutes, and their reliable courts. But at the same time, you can avoid, let's say, the nasty side of the United States, which is that heavy tax burden which is usually associated with the country. So in this case, what I mean to say is, if you are an international entrepreneur or investor, you could potentially be in a situation where you could really have the best of both worlds. And a U.S. trust means easier access to U.S. banking, U.S. financial infrastructure, U.S. wealth management providers. It also means that in many cases, you will not have any blacklisted related issues. Now, before I go, I also want to point out that there is one other mechanism through which you could potentially get a tax-neutral U.S. trust, which is when you form a Foreign Grantor Trust in the United States. Now, the Grantor Trust rules are, again, very complex, so I'm just going to lay them out to you just in general terms so you have an idea. But essentially, in certain cases, when you are a foreign settlor of a trust, you could wind up in a situation where the IRS will say that for tax purposes, they're not going to actually look at the trust as a standalone taxable arrangement, but they're going to look at the actual settlor or grantor of the trust, which would be you, the person who actually put the assets in the box. Now, in the case of foreigners, the situations where this can occur are actually quite limited, but generally speaking, if you are creating a self-settled trust, meaning a trust that you create mainly for asset protection, and whose beneficiary is also you or your spouse exclusively, then you could be treated as a grantor trust for U.S. tax purposes. And in addition to that, if the trust is fully revocable and you as the settlor are a foreign non-resident alien, you could also be potentially treated as a foreign grantor trust. And in essence, what that means is the U.S. is going to look through the trust and is going to apply the tax rules that are applicable to you as a non-resident alien in terms of the taxability of the income generated by the trust. You will have foreign source income generated by the trust essentially not be taxable in the United States, just as in the first scenario, and only U.S. source income will be subject to U.S. taxation. So bottom line here, folks, you can have a U.S. trust formed under U.S. law. There are two scenarios in which that trust could potentially only be subject to U.S. tax on U.S. source income, but it is very delicate, very precise, it requires proper planning, and it requires somebody who truly understands the intricacies and the details of cross-border global taxation to actually make it work. So, if you are interested in potentially exploring a tax-neutral U.S. trust, if you really want an alternative to a classic offshore BVI, Cayman Islands, Cook Islands trust, and you're ready to go to the next level with a top-tier jurisdiction like the United States, but you want somebody who's going to help you structure this properly from a tax perspective, go to rothbardgroup.com. We welcome the opportunity to work with you. And this was Javier Correa, the tax director for the Rothbard Group.